So thank you, Roger, for allowing me the opportunity to speak. And I don't know the status of this organization's tax exemptions. I'm going to try not to ruin that before it gets off the ground. I'm not going to name any political candidates by name, and I'm going to try to not make this overly political in general. I don't want to turn anyone off. My aim today is to try to elicit a conversation about a topic that's relevant, I believe. We've got elections coming up. You guys are starting to see yard signs around town. If Mr. Westerfield, my 12th grade government teacher, taught me, and I remembered anything, I think the primary is the fourth Thursday in May. So you guys, if you haven't registered to vote, I would encourage you to do that. And what I want to talk about today are a class of folks who aren't able to vote. And so I've loosely labeled this discussion, "Every vote counts unless you can't vote." I think that maybe as an attorney, I'm going to take certain terms for granted because I've just learned what they mean and use them on a daily basis. Please don't hesitate to interrupt me if I use a term that you're not familiar with. Let me start by saying, when I'm talking about a felony, I'm talking about any crime for which a person has been convicted, that the potential penalty carries more than 1 year in prison. Okay? So if someone gets a DUI, that's not a felony. Something you go to jail for a couple of days is generally not a felony, although you don't have to ever have gone to jail or prison to be a felon. You can be placed on probation. So that's one of the terms that I wanted to identify from the outset. And there's three main reasons that I think the issue of disenfranchisement, that is taking the vote away from somebody, there's three main reasons I think that it's important. One is, I think we can all agree that we feel as if we have more faith in the political process when people turn out to vote. I feel this way anyways, and I, again, welcome discussion on this point, but I like to be able to come home after I voted on Tuesday and turn on the news and see that number, the percentage of turnout. The higher that is, the better I feel. Because I think the more people that have a say in the process, the better that candidate is going to be at representing those folks that have actually voted. So that's one reason. I think it gives us better candidates and better political operatives, whether they be in Frankfort, whether they be at City Hall, or whether they be in Washington, D.C. The second point is similar to that, but it's more in giving people a sense that they have a stake in the game. It's such a big country, it's such a big state, and it seems to grow by leaps and bounds with the more technology we have and the more social media we have. But I think that it's important that people feel connected to the process. And I think when the connection starts to falter, we see upheaval. We can take the Ukraine as an example. So I think more esoterically, people feel as if they have a stake in the game if they're allowed to vote. And the third reason, and the reason why it's on my mind, is this issue is very likely going to be placed on the ballot come November of this year for all of us to have a say as to whether or not we want to amend the Kentucky Constitution. It's going to be a ballot initiative more likely than not. And I'll talk a little bit more about the status of what the law is in Kentucky right now, what I think about it, and then hopefully elicit what your all's thoughts are. So let's talk numbers. As of 2010, the Sentencing Project estimated that in the United States about 5.85 million people are disenfranchised due to a felony conviction. That's about 2.5% of the nation's voting age population. In the state of Kentucky, over 240,000 people have been disenfranchised by a felony conviction. That is 7.35% of Kentucky's voting age population. That's a big number, folks. To put it in context, we have the third highest percentage of our population in the nation, behind only Florida and Mississippi. If you'll look at the top 10, you will see that generally the states that have the highest rate of disenfranchisement as you all might be able to guess, are in the Southeast. So those are the kind of numbers we're talking about. When we're talking about 7.35% of Kentucky's population, or 2.5% of the nation's population, think of the game change those people could possibly be. Again, I'm not going to name anybody by names, but there was a really closely contested election back in 2000, you guys remember, for the presidency? Just this last election cycle here in Davis County, there was a race decided by 5 votes out of over 15,000 votes cast. The person that ended up being elected is no longer serving, but it just goes to show that every vote does count if we can get people out there voting. So originally this was going to be more about the history of disenfranchisement, and that's what I told Roger I was going to talk about, so I apologize if I'm switching gears ever so slightly. I am going to just briefly say that the tradition of disenfranchising convicts dates back to Roman times. There is a long tradition in Western civilization. Although in Roman times, the people eligible to vote from the outset was a much more narrow class of people. There were people who were entitled to vote, but as maybe they did something, they killed somebody, they stole from somebody, they would lose that right to participate in the political process, something akin to shunning, and then or being banished from the community. Moving up in time through the time when the British Empire ruled the world, or our part of the world anyways, there were a couple concepts of outlawry and attainder. Attainder was basically the government taking from you your titles, your land, and your ability to participate in the political process. That way of thinking came over with the folks that settled the colonies. And in colonial times, there were generally restrictions placed on who could vote, but also people could lose the right to vote once they had already gained it. Now, back in those days, as you guys know from your middle school and high school days, or just because you have a TV at home and a brain in your head, property-owning men were the class of folks who were allowed to vote. And this is where I think it's really interesting, because as we have progressed through the years, generally speaking, we have broadened the classes of folks who can vote. Starting with, let me take a step back. When the founders that drafted the U.S. Constitution got together, they delegated to the states the ability to set the qualifications on the state level as to who could vote. All right, that's just a general principle of federalism, that the founders wanted the local folks to be able to determine how it was they chose their leaders. But as time has passed, there have been certain restrictions placed on the states, things that they can and cannot use as a basis for keeping people from voting. As for example, the 15th Amendment, which was one of the Reconstruction era amendments, passed in 1868. The 15th Amendment says no state can discriminate against a potential voter or keep a person from voting based on their race or their creed or the fact that they used to be a slave. Okay? The 19th Amendment, which was passed in 1920, gave women the right to vote. The 23rd Amendment, which was passed in 1961, gave those people living in the District of Columbia the opportunity to vote for presidential elections. And the 26th Amendment in 1971 lowered the voting age from 21 to 18. So as I see it, there has been a general trend in our country to allow as many people as possible to have a say in how our leaders are chosen and to choose those leaders. This disenfranchisement of felons, I think, stands out in contrast to that general trend. And in 1974, the Supreme Court, in a case called Richardson versus Ramirez, heard a case that came out of the state of California. And the state of California at that time had a law on their books that said anybody that had been convicted of a, quote, infamous crime would lose the right to vote. Now, I'm not going to pretend to have read the entire Richardson versus Ramirez opinion because it's about 50 pages long, but I did do enough research to be able to summarize it hopefully in a couple of lines. Essentially, the High Court of California sided with these people that said, we think this is wrong. The California Supreme Court said, you're right, we're going to strike down this law. You can't prohibit infamous criminals from voting if their sentence has been served. The U.S. Supreme Court, this was during the Burger Court, if I'm not mistaken, ruled on a 6-3 basis that in fact you could keep people from voting. And the language they cited to, ironically, was the second section of the 14th Amendment. And most of you guys, to the extent you're familiar with the 14th Amendment, are familiar with the first section of the 14th Amendment, which deals with due process and equal protection under the law. The second section of the 14th Amendment, and I'm going to bore you with a bit of the actual language from the 14th Amendment, is what the court relied on in upholding the California law. What the second section of the 14th Amendment says is, when the right to vote at any election for the choice of electors, yada yada, is denied to any of the male inhabitants of such state, being 21 years of age and citizens of the U.S., or in any way abridged, except for participation in rebellion or other crime, the basis of representation therein shall be reduced in the proportion which the number of such male citizens shall bear to the whole number of male citizens 21 years of age. So what they're saying is, the folks who drafted the 14th Amendment said it's perfectly okay when we are determining how many electors each state gets. And back then, electors were used to determine the president and I believe also the Senate. I don't think that changed until much later in time. So what they were saying is, if you can exclude people who had participated in rebellion or other crime, if you could exclude those people from the population used to determine how many electors each state got, it stood to reason that was a just basis for keeping criminals from voting. Now, that's not to say every state has to do that. It just says every state can do that. Is everybody with me so far? Yes. All right, good. So, currently, many states still have restrictions on who can vote after having been convicted of a felony. There are 2 states that have no restrictions, and it probably doesn't come as a surprise. It's Maine and Vermont. In Maine and Vermont, even if you are in prison for murder or for rape or for gosh knows what, you can send in a ballot. There are absolutely 0 people in Maine or Vermont who cannot vote because of a felony conviction. As I mentioned earlier, Kentucky is in not so great a position as far as that goes. And this goes to Section 145 of the Kentucky Constitution. And I'm going to bore you once more, but I think the language is insightful, and I also think it kind of speaks to where we were back in 1955 when this was ratified as part of our Constitution. So it says that every citizen of the United States of the age of 18 years who has resided in the state 1 year and in the county 6 months, and the precinct in which he offers to vote 60 days next preceding the election, shall be a voter in said precinct and not elsewhere. But the following persons are excepted and shall not have the right to vote. Number 1, persons convicted in any court of competent jurisdiction of treason, of felony, or bribery in an election, or of such high misdemeanor as the General Assembly may declare, shall operate as an exclusion from the right of suffrage, but persons hereby excluded may be restored to their civil rights by executive pardon. Number 2, persons who, at the time of election, are in confinement under the judgment of a court for some penal offense. Number 3, my personal favorite, idiots and insane persons.
Wow, that broadens everything.
Right? Are you glad I read that? Right?
Many of us shouldn't be voting.
So, I'm not making that up, guys. Idiots and insane persons. And that's what I said by, I think that language right there says an awful lot about how much society has changed since this was originally drafted. The first section excludes felons, which I've talked about. The second section, and this is where Kentucky is maybe even harsher than most other jurisdictions. If you are in jail for any offense, come election time, you don't get to vote. You don't get to send in your absentee ballot. There's no polling place at the jail. Even if you're just there overnight for a silly offense, you picked the wrong time to go to jail, sorry, we're not going to let you vote. Okay? Again, I think that's kind of harsh. I think that what's going on right now, both nationally and on a state level, I think there's good momentum to try to change some of these things. There have been many attempts in the Kentucky legislature to change the Kentucky Constitution. There's a gentleman whose name escapes me, a representative out of Louisville, who's retiring this year and has consistently tried to push this issue. He's an African American representative. I want to say Crenshaw or Cunningham, but don't quote me on that. In any event, he has proposed some legislation which actually passed through the Kentucky House that said once you have finished serving your sentence or finished your period of probation or parole, you will automatically be entitled to vote, with the exception of murderers, rapists, and any people convicted of a sex crime against a juvenile. Okay? My thinking is he added in those qualifications because it would sit with voters a little bit easier. I'm not saying that, in my mind, even if you have murdered someone, even if you have committed a sex crime, I don't know that necessarily means you're not intelligent enough to pick your representatives, but that's the language that's been placed in the bill that passed the House. So the way it works is after it's passed by the House, it then goes to the Senate. And here's where I think things get a little bit interesting. Rand Paul, our U.S. Senator, who is fairly conservative, I think, on most issues, actually came down to Frankfurt and spoke in committee in favor of the House's proposal. He is kind of beating the drums against the war on drugs and the collateral consequences of the war on drugs. And one of the issues that he's picked up on is, why can't these folks vote after they're released from prison? The Senate in Frankfurt made a few changes to the House's proposed language. They have added a 5-year waiting period after you leave prison or after you are finished with probation or parole. And they say that anyone who has been convicted of more than one felony shall be excluded. And anyone that, I think they broadened the types of sex crimes that could be used to exclude potential people from regaining the right to vote. So where we are now is the way this process works. The House passed a bill. The Senate's bill is different. The Senate's bill has to go to the House to see if the House can agree with the changes that have been made. It's my understanding that's not likely to happen, which means this issue will go to a conference committee. I hate to bore you guys with this, but I think what's going to happen in the next month or so is people from the House and people from the Senate are going to meet behind closed doors and hammer out some sort of agreement as to how this looks. Okay? I think it's very likely that in some form or fashion, come November, it's going to be put to us, the voters, to decide whether or not these folks should be allowed to vote. I will tell you that generally speaking, the trends throughout the country are that Republicans tend to disfavor this type of legislation. I think their thinking is folks that would regain the right to vote are less likely to vote Republican. On the other hand, Democrats, I think for just the opposite reason, are more in favor of this type of legislation because they think the more of these folks we can get to the polls, the better off their candidates will be. I'm not saying that the Republicans that the Democrats are really high-minded and the Republicans are juvenile in their thinking. I think they're both out to serve their what they see as their best interests. I don't know if they're right or not. I think only time will tell. I also think it's interesting that not only has Rand Paul weighed in on this, but the Attorney General of the United States, Eric Holder, has also been making this a bit of an issue. And for those of you that aren't familiar with what it is the Attorney General does, he is the top law enforcement official in all of the United States. He's appointed by the President. Mr. Holder has been serving in that capacity since Mr. Obama took office. And he made remarks not too long ago at a function in Washington, D.C. at Georgetown University that he singled out Kentucky as an example. I think Mr. Holder looks at this as a disability that disproportionately affects folks of color. 1 in 5 Kentuckians cannot vote. One in 5 Kentucky males cannot vote due to felony disenfranchisement. So these are real numbers. I think that there are real consequences to how this ballot initiative is going to turn out. Again, for those folks that aren't registered to vote, I would encourage you to do that. Have your voice heard on this matter. That's about all I was going to say. I do want to, I guess, share how it was that I became interested in this. Valerie had mentioned that I was a public defender in Frankfort. And for those that thankfully haven't had to go down to the courthouse and see how it works, my job as a public defender was to represent those folks on criminal cases that couldn't afford representation. And when I would go through a guilty plea with a particular client, there is language in there that talks about losing the right to vote, losing the right to run for office, losing the right to carry a firearm. And I have to go over all that stuff with individuals because their plea has to be knowing, intelligent, and voluntary. And the court will ask them these questions to make sure they're aware of what it is they're getting themselves into. And I would always make a point to tell these individuals that, and very rarely did it seem to have any effect on these folks. Very rarely. And I think that's for a couple of reasons. One, they're trying to stay out of prison. You know, and when the stakes are such that, okay, lawyer, let's talk about how you're going to keep me out of prison. I'll worry about the right to vote when I walk out of this courtroom in my own clothes. I can understand why those folks, it's not the foremost concern on their minds. But I don't think that makes it any less important for the rest of us. And I think that if you read up on what's going on, a lot of the positive momentum behind the changes that are happening are folks that have been released from prison, that now this is a big deal to them, and they want to try to make a change. So I appreciate you guys listening to me. I'm happy to try to answer any questions you may or may not have. My thinking is many of you are probably as informed on this as I am, but yes, sir.
I had a conversation with you shortly after you started visiting our church about this subject. And my question to you now is the disenfranchisement of homeless people. A lot of those being veterans of the United States military. How do we correct that problem? Or
Well,
is it correct?
This is kind of a parallel issue in my mind, that the disenfranchisement is gaining a lot of steam, but on the other hand, we have legislation in many states that are trying to require folks to have government-issued voter ID before they can go to the polls. And it's in these circumstances, I think, that homeless folks, veterans are most directly impacted. Because if you don't have an address to call your own, what precinct do you vote in? How do you go about proving that you are a resident of that particular precinct? So what I'm afraid we might find is that at conference committee, and I'm basing this based on some comments made by a guy named Damon Thayer, who's the Republican leader in the Senate, that he has said, you know, this is an issue that I'm willing to take up, the felon disenfranchisement, but I also want to take up the voter ID issue. And he says, you know, let's see if there's not some way that we can, I don't know that he said this, I'm reading the tea leaves, to try to merge these issues. So what I'm afraid we may see is some sort of initiative that might open up the door to voting for some folks and close the door to other folks. So I think to the extent those issues are interconnected, that's a big way that they are. Yeah.
I'm always asked to show my ID when I vote here. Do we have to?
I think you have to show some form of identification. I don't know that it has to be a government issue, photo ID. And the reason that this is an issue for folks of little to no means is I think it costs $20 to get a new driver's license right now.
$23.
$23, and I'm sure it's going to continue to go up. And the thing is, if you don't have a car, what's the pressing need to go spend $23 on a government-issued ID? Because they'll sell you one. Sure as anything, they'll sell you an ID. It's just an identification card, but I got my Social Security card. What do I need that? Why am I going to pay $23 for that? Or I've got a bill with my name on it. Yeah? Yes, sir.
Biometrics.
Maybe. Here's
I don't see
been.
any other way to do it. Your fingerprints are on file, it's more.
It's an issue of cost, I think.
That fingerprint, your footprints are important.
Yes, ma'am.
They don't do fingerprints.
Our first principle is the inherent dignity of every man and woman, or whatever. How can we as a congregation accept what you have said and maybe fight for the homeless, the veterans that don't have residence to live in, and the people that have, convicted? They're still got the dignity of a human being. And to me, I think 2 or 3 years ago, I probably would have been on the other side and said, because that's the way I was taught. But as you expand your mind and accept people for who they are as a human, how can we help?
Well, I think that generally speaking, when people ask, how can I be a part of the process, it's a difficult question to answer because it's such a big and kind of unwieldy system that we've created for ourselves. I think in this particular case, we do have a leg to stand on, and there is something we can do because it's going to be put on the ballot. All right? And we get to decide without any interference, for lack of a better term, of the folks that we previously elected. I know that there could very easily be a town hall discussion on this. The barbecue festival every year has political candidates that come to town, and that's moderated by, amongst other folks, my father. I'm thinking that this is an issue that could be brought up at a forum like the barbecue festival. I also think, to a certain degree, we could develop a message which would be simple enough, clear enough, and short enough to put on yard signs. And you see him from time to time vote yes on Prop 164. I don't know that that's the most effective way of doing it because what is Prop 164? I mean, nobody knows unless you're really super invested in the situations, but just something as simple as felons should vote too, or felons are people too, or, I love a felon, or something of that. You know what I mean? They're people.
Everyone should vote.
That's right. Yes, ma'am.